Your Honor, if I could just add real quick, I think technically just because there's been the order to conduct the evaluation in the first place, there's technically supposed to be an adequate hearing finding Mr. Ibarra competent to proceed. This is that hearing. We stipulate to the report. I think the court just has to find him competent, which we have no objection to.
There is certainly a factual basis for this court to find him not only competent at this time, but competent at the time of his trial. And that factual basis is not only an absence of evidence that he was incompetent, but the factual basis is the report that I have submitted to Your Honor that has now been filed as State's Exhibit 1 or admitted as State's Exhibit 1. I disagree with defense counsel's interpretation of 17-7-130, especially as it has been recently amended by the Georgia legislature in July of last year. Both the Uniform Superior Court rules and our statute requires them to file a special plea of incompetency. When that happens, then the rules are triggered where we have a trial. What is contemplated in our statute is a bench trial, but either party would have the right to a jury trial on that issue, and it's a quasi-civil or civil criminal proceeding. I think based on our record at this point, it doesn't really matter. I just don't agree that they filed a special plea of incompetency requiring that finding, but you certainly have a factual basis to make that finding, and it seems to me that that's what they want you to do. So I would have no objection to you making that finding. I just don't think it is required by our statutes or the Uniform Superior Court rules.
I agree in reviewing the pleadings. There was no special plea filed by the defense. However, the evaluation was done. That has been admitted. That has been reviewed by me. I will sign an order that finds the defendant is competent at this time and was indeed competent as well at the time of trial based upon the report and the other matters that are of record that the court has participated in, including Mr. Ibarra.
Thank you, Your Honor. No objection.
All right. Does either side want to be heard about whether or not this evaluation should be placed under seal?
We would request it be placed under seal.
State have a position?
I won't oppose it, Your Honor, and defer to the court.
Okay. I will place that under seal, but it will be part of the record.
Thank you, Judge.
All right. Does that take us then to the amended motion?
To the amended motion for new trial, which you are ready. We do have one witness, Dr. Susan Ballard, who would be testifying via WebEx.
Okay.
Dr. Ruth Ballard. I apologize. Dr. Ruth Ballard.
That's all right. Do you want anything preliminarily before?
Just preliminary. Preliminary for the court, we've raised 3 enumeration of errors. The first error was this honorable court's order denying a continuance violated Mr. Ibarra's 6th Amendment rights to counsel and his 14th Amendment right to due process. Enumeration 2 is the court's order denying a continuance constituted an abuse of discretion. And count 3, the court erred when it denied Mr. Ibarra's motion to suppress that was heard prior to trial on the cell phone evidence. Today we are we have Dr. Ballard, who will be here to testify, and that her testimony goes to the first 2 enumerations of error. We're ready to proceed with testimony at this time.
All right. Anything from the state?
I do have some documents that I'd like to use to supplement the record as it pertains to enumeration of errors 1 and 2. I can do that when we're doing argument on the case because they are self-authenticating documents, or I could just do it now and then we'll take the testimony from Dr. Ballard and then we'll have argument. I'm assuming we're arguing after testimony.
We would be requesting a briefing schedule. What we would ask for is after the transcript has been filed of Dr. Bauer's testimony to have a briefing schedule so we could submit a written brief.
Okay, well, pre-permitting your order on that, Judge, if I could then just go ahead so I don't forget, and it's just part of the record, should we brief it or argue it today, of the documents that I've shown to defense counsel, which States Exhibit 2 and 3. One's already been admitted.
No objection.
And for the record, States Exhibit 2 is just a GBI record certification that shows how and when the raw data in this case was distributed to trial counsel and when they accessed said data. And then States Exhibit 3 is just my letter dated September 17, 2024 to the GBI requesting the raw data on behalf of the defense. And I should note for the record that States Exhibit 2 is a composite exhibit. It has 3 documents. May I hand it to the court?
That's fine. Put it in the court order.
Thank you.
Claims 2 and 3 are admitted. You want me to give him his, Dr. Ballard?
Yes. Your Honor, would it be better for us to question her at table or use the podium?
That is good if you can do that because there's a microphone there. I understand you might be using the podium for a display.
Yes. I can just go up there when I need to use it.
That sounds
There's only
fine.
one part
That
of it, and
sounds
it's
fine.
kind of, that would be fine.
Let's see. Dr. Ballard, can you hear?
I can.
All right. And you see Mr. Latrell here? Do you see Mr. Latrell, counsel?
I believe so. Can you raise your hand? Yeah, okay. Yes, I do.
All right.
Dr. Ballard, can you hear me?
Yes, I can.
Okay.
You may proceed.
All right, Dr. Ballard, if you could please raise your right hand. Do you solemnly swear or affirm the testimony you're about to provide the court in this matter is the truth and the whole truth, you so swear or affirm?
I do.
All right. Dr. Okay. All right. Dr. Ballard, could you please state your educational background?
Yes, I have a bachelor's of science in biological sciences from Sacramento State, and then I have a master's degree in genetics with an emphasis in human genetics from UC Davis, and also a PhD in genetics with an emphasis in human genetics from UC Davis.
Thank you. And what kind of work do you do, Dr. Ballard?
Well, currently, I'm working full-time as a forensic DNA consultant, but my primary career from about 1996 to 2024 was as a professor at California State University, Sacramento, where I taught the program in forensic biology and DNA, and I developed and taught it and did research in that discipline.
Okay. What were the duties of your job as a professor when you were a professor, doctor?
Well, there were 4 general duties. One was teaching, and that was primary at that particular university. So I did a lot of curriculum development and working with students in the classroom. And the primary thrust of what I was doing was to train students that wanted to become crime lab workers when they graduated from college. So the second part of that, and important part, was research. So I ran a research lab both there, and actually I ran one for 5 years at UC Davis as well in their forensic biology or forensic science graduate program. And we studied various questions in forensic serology and DNA in the laboratory using the same technologies and approaches that are used at modern crime labs. We also got, professors are required to be involved in committees and university governance, and then I also did community service as well as part of my job.
What are your duties in your role as a forensic serology and DNA consultant?
So primarily what I do is that I do case reviews. And what those consist of is I get contacted by an attorney, usually a defense attorney. Those are the ones that contact me. And they say, I've just been given some legal discovery around DNA evidence in my case, and I don't have a background in that, and I need an expert to look at it and tell me what the strengths and weaknesses of the prosecution's case are in terms of the DNA. Make sure the work was done correctly, that you don't have any issues with that, and then help me understand and interpret how this plays out, in the particular, given the particular context of the case. So that's essentially what I do. That usually includes a review of any crime lab reports, the analyst bench notes associated with those reports, electronic DNA data files associated with those reports, and then these days especially, I look closely at probabilistic genotyping. Statistics is usually what people are using, so I'm looking at those reports and so forth. And then once I have gone through all of that, I then usually meet with the attorney and discuss my findings. And then beyond that, I will also look at the context of the case. So what are the charges against the client, read the police reports, look at sexual assault examinations if it's a sexual assault case, or autopsy or things like that if they're relevant. So all of that I look at, and anything else. Sometimes there's body cam video that I look at. So anything else that's pertinent to understanding the DNA in context.
What's the difference between forensic serology and forensic DNA?
Well, forensic serology is a lot older to begin with, and that is the detection of body fluids. And so these are tests that look for the presence of, for example, is this red stain likely to be blood? Is this clear stain saliva? Could it be semen? And then looking under the microscope, looking for spermatozoa. Those are typically the tests that we do. And the reason we do it is you could imagine if you had, say, a bed sheet and it had some stains on it, maybe they're clear in color, and you really don't know where to go to find stains that would likely have DNA from either the victim or the perpetrator or both. And so we use these screening tools to locate these stains, body fluid stains, and then the cells and the DNA that they contain, ultimately to get DNA profiles from that evidence. So it's largely a way of finding evidence, but it also tells you something about how the evidence got there. So obviously, if you have spermatozoa and you get a single source male DNA profile from that sample, then you know that the source of that, the bodily source of that DNA was sperm. So it tells us something about also the transfer that happened.
Okay. Are there different software programs or tests which can be used for forensic DNA analysis?
Yeah, I mean, there's, so basically a forensic DNA analysis usually starts with the DNA extraction after the serology is completed. And this involves taking whatever substrate you have, which might be a swab or it might be a cutting, say, from a piece of clothing, and soaking it in some buffer and a little bit of detergent and an enzyme called proteinase K, and that helps the cells come off of the substrate if there are any cells there, and then pop open and release their contents. After that, there's DNA extraction or purification, which purifies the DNA out of all the other cell contents, like proteins and lipids and other molecules that we don't want in our preparation. And that's typically done on robots these days. So there are robotic instruments that do that with various chemistries involved in that. A very popular one is the Easy Run, and it uses a sort of a what we call silica bead preparation to do its purification. But anyway, there's different techniques. There's a variety of them out there on the market. Once we have a purified DNA extract, the next step is to figure out how much human DNA we have, if any, and if any of that human DNA is male in origin. So try to get a sense of whether or not we have a mixture of female and male DNA, whether it looks like it might be all male DNA or whether it's all female. And that's really important, especially in sexual assault cases, because if you're screening sexual assault evidence and you don't find any male DNA, and the allegation is a female victim with a male perpetrator, you're probably not going to take that sample forward for analysis. So it's a very important step. It also informs us about how to set up our DNA profiling downstream, how to set up that reaction. So there's a lot of information. It also tells us information about whether or not the sample's degraded. So there's a lot of good information in that quantitation step. And that's done by a procedure called qPCR. And that uses real-time qPCR instruments. And it uses one of many types of chemistries that are available on the market to do that.
Thank you.
And then finally, there's also DNA profiling. That's where we actually amplify short regions of DNA that are different in different people in the population. Those are called short tandem repeats. And we amplify those. We create millions of copies of them. And we do that on an instrument called a PCR instrument or thermocycler for the amplification. And then we move that over to a capillary electrophoresis instrument, which separates and detects the fragments and produces a DNA profile. And then we use computer software. GMAP or IDX is the most common one for analyzing the DNA profiles and making our interpretations. And then once that's completed, we may or may not use one of these probabilistic genotyping programs that allows us to do a more sophisticated deconvolution and analysis, especially if we get a complex low-level mixture of DNA. So all of those are used. There's also a bunch of kits on the market for doing DNA profiling. So there's options out there for different labs, and different labs use different ones, but they're all operating on sort of the same technology.
Okay. What is your understanding of the TrueAllele software, so the TrueAllele program? So
TrueAllele is a probabilistic genotyping program. And just to give just a little bit of background, when our chemistries and instruments started getting really sensitive, what we realized was that if we went and started swatting doorknobs and steering wheels and items like that, that people had merely touched, that we would oftentimes get very low amount of DNA, but we would be able to detect it, and complex mixtures, so mixtures of 3 or 4 different people. And at the time that we started to begin to detect it, we didn't have these probabilistic genotyping tools to assist us as analysts in our interpretation. And so it was really difficult. We had to do what are called manual interpretations, and different laboratories around the country were doing them differently and coming up with actually different answers to the same profiles, which we found out when NIST started sending around a whole bunch of profiles to different labs and asked if they could get the right answer. So we knew there were some issues with our manual interpretations, that we needed some help with it. And some of these big data companies got involved, and they used biological modeling, sophisticated biological modeling of how these profiles behave, and then also computer algorithms to deconvolute complex DNA mixtures into their component parts, and then compare persons of interest, victims, suspects, whoever, against those deconvoluted profiles to see whether people were included or excluded, and with what statistical weights or confidence we could say that. And so these tools have really been a big change to our profession. Most labs had them on board around 2020. Some labs are still adopting them, but one program that's out there is called StarMix. That's the most popular around the country. It's used more often than other programs, but TrueAllele is also well regarded, and it's used by I don't know how many labs in the country now. Not as many as StarMix, but it's used around the country as well.
How long has TrueAllele been in existence?
I think it's been around quite a while, in sort of beta format. So, I think some of the papers started coming out maybe as early as 2000 from Mark Perlin and others, he's a major developer of it. But in terms of adopting it, most labs weren't adopting those kinds of probabilistic genotyping programs until around 2015, 2016, something like that.
Okay. Now, the companies that design the DNA software for comparison, did they provide training for, open training for experts such as yourself to review how they collect and analyze the data?
Well, so StarMix does. StarMix has two trainings. They have an introductory training, which is a week-long training, and they also have a virtual advanced training. And I've taken both of those. And as an independent DNA expert, I was permitted to sit in on those and participate as a full participant. And I was able to purchase the software, and I was able to use it in my own laboratory at Sacramento State, and then I also use it in my work as an expert. TrueReal is a little bit different. Cybergenetics, and I'm not saying there's anything wrong with the company. I'm not saying anything bad about them, but they don't have an open training for analysts like myself. Now, that being said, they've been helpful to me when I've had questions. It's just that when I asked if I could purchase the software and if I could become fully trained, they're not doing that yet for independent experts, at least at the time that I inquired about it, which was fairly recently, within the last year. So, so I'm not, I admit today, I do not consider myself to be a top expert on TrueAllele. I have done a research study with a student at UC Davis and a colleague named Dr. Ruth Dickover, who used to run the Kern County Crime Lab. She was the DNA technical lead there, and they use TrueAllele. So I learned a lot about TrueAllele from her, and during the course of that project where we compared the performance of TrueAllele and StarMix, but I have not taken any formal training from cybergenetics for TrueAllele. And when I have a case that involves TrueAllele, I usually contact them and get advice on reading the reports and things like that, just to make sure I'm getting it right. I do consider myself to be a good expert on StarMix, which is the other probabilistic genotyping program, and they operate under similar guidelines, but there are a number of substantial differences as well.
All right. And have you testified as an expert in forensic serology and DNA?
Yes.
Okay. And how many times have you testified as an expert?
I think as of today, about 53 or 54.
Okay. And in those cases, and have some of those cases involved TrueAllele?
Yes, they have.
Okay. And let me ask you, do you only testify for the defense? Do you ever testify for the state?
Rarely. I have testified for the state, but and I'll say also, when we're talking about criminal matters for the state versus the defense, it's the defense attorneys that contact me because the prosecutors use the criminals at the crime labs as their experts. So that's the reason. It's just sort of the way it's set up, the system's set up. When I'm doing civil litigation, I'm about equally between plaintiff and defendant in terms of who contacts me. But in criminal cases, it's almost always the defense.
Okay. And what jurisdictions have you testified in?
Oh, my goodness. Well, I've testified in, I think, 25 counties in California. I've testified in Arizona. I've testified in Nevada, Washington State several times. I've been to Illinois, Wisconsin, Georgia. That's something I'm thinking about. But yeah, Idaho. The recent was in Idaho. So, yeah, all over the place.
All right. Your Honor, at this time, we would move to admit Dr. Ballard as an expert in forensic serology and forensic DNA.
Any objection, Ms. Ross?
I guess, Your Honor, at this time, I need to, I guess, ask defense counsel, is she going to be offering any opinions on TrueAllele or just forensic DNA in general?
Her primarily is going to be testifying as to forensic DNA in general, but she may have some comments about the TrueAllele.
Okay. If I may just voir dire a little bit then, Your Honor, and then the best way to do this probably is for me to make a contemporaneous objection if I believe she has strayed outside of her expertise, which I will do. Just for background for the record, because none of this is on the record, at 4:15 p.m. last night, I got her expert report, which is 6 pages long. Had we not been in this posture, I would have, one, reached out to the doctor and, hello, Dr. Ballard, we've never met. Hope you're feeling better, which was not able to happen under the circumstances that I was put in. And also, I may have, after speaking with her, potentially filed a Daubert on this issue. Because we are not before a jury, and Your Honor would be hearing the Daubert anyway, and Your Honor will be the fact finder, I'm putting this on the record to let you know I'm not waiving any Daubert issues. I may actually supplement the record after this testimony in regards to the reliability, repeatability, Daubert factors. But I need to explore some things that I normally would have done in a Daubert hearing that we were just unable to do so because of the timing. So with that, if I may just voir dire a little bit, and then I'll probably just make an extemporaneous objection if I believe she's straight outside the expertise.